this is Alan Gassman, and it is 5 p.m. on Thursday, August 18, 2011. We welcome you to our webinar on major changes in the Florida law. That's the Florida Power of Attorney law, and we are especially pleased to have Judge Jack St. Arnold here with us today to get some of his comments, and my partner, Crotty Denicolo, is here as well. We also have a couple of Stetson Law students who have been working about 2 weeks on this outline, and we've learned a lot writing the outline. We want to thank all the attendees. We have about 75 attendees right now, most of them lawyers, most of them who will be as confused as I am before we're done here. There's plenty to learn, a lot of really interesting things. So I'm going to go ahead and go to the table of contents on page 2. Now, if you're watching the screen, you should see the table of contents. If you pre-signed up for this, then we sent you the PowerPoint a few minutes ago, I think about an hour and a half ago, because we finished it about an hour and 31 minutes ago. If you haven't gotten the PowerPoint and you want to be able to print it, you can just email Janine, Janine, at Gassman, Gassman, or if you have any questions for the speakers, you can email Janine at gassmanpa.com or Alan at gassmanpa.com, and we'll try to answer your questions during the presentation. If you have any technical issues, you can call Janine at 442-1200, extension 8, and she will solve whatever technical issue you have. In fact, she'll come to your home and fix your laptop. So just let us know. So the table of contents on page 2 can tell you where we're heading. The red ball is what we're going to try to guide you with, so you can see what I'm seeing. Page 3, I wanted to thank Karen France for all of her help in helping to invite people and giving us ideas for this webinar. We're going to talk about France on page 13 also. We can mention Karen then, but thanks Karen, bye. Page 4, wanted to plug our friends Hamden Baskin and Jay Fleece, certainly the go-to people for trust disputes. They are speaking on September 15th at noon to 1 o'clock on pitfalls in litigation under the new Power of Attorney statute. We're going to be there watching and listening because we want to know what they think about all these issues. Page 5, if you're interested in more webinars, we don't charge for these webinars. Next Thursday, August 25th at 5:30, I'm going to be speaking with an insurance agent for 15 minutes on what Mary Poppins didn't know about umbrellas to help you make sure that your clients don't have gaps in their umbrella coverage. Also, Monday, August 29th, we're going to be talking on special planning needs for doctors who are married to doctors. Most of you don't have that problem. Most of you are lawyers. Some of you may be married to doctors, but this is just for doctors who are married to other doctors. Then we're going to do a 15-minute guide to this new Power of Attorney Act on Tuesday, August 30 at 5:30, and we're going to talk more about insurance gaps Monday, September 12, 5:30, Riders on the Storm, how to make sure your insurances don't have any catastrophic exceptions. We do a lot of work for physicians, and we really find that helping them look at the basics of their insurance coverage can be very important in their planning. Page 6, if you'd like to see one of our prior webinars, they're on our webpage. We've got a list of them here. And this webinar will also become accessible to you and anyone you may want to have see it on our website just by pushing a button. We will also replay this webinar next week, 1 week from today, at 6 p.m. That's next Thursday at 6 p.m., right after the Mary Poppins presentation. Page 7. We donated 30 copies of our new book, Estate Tax Planning in 2011 and 2012, to the Clearwater Bar Association. If you fill out this form and send it to them with some money, 100% of the proceeds will go to the Clearwater Bar Association, and you'll get this book. And guess what? It's not out of date yet. In fact, I can't think of anything that's changed since it was printed. Page 8, I have citations for you. If you're like me, sometimes you want to read the law, you want to read other articles, you want to read regulations. We've got them all there on page 8. If there's anything you hear tonight that you want more information on, please send us an email. We're going to be converting this into an article for publication, and we're very interested in all of your questions, comments, and suggestions. Page 9, an initial summary. Guess what? There's a new Power of Attorney law. And about 3 weeks ago, a very good lawyer called me on the phone and said, Alan, what do you know about the new durable power of attorney law? And I said, I don't really know much about it. I'm not that concerned. I'll just read the law, and I'll get back with you. Well, I'll share our new forms with you. Well, I started reading the law, and I got concerned. There are a lot of changes here. This October 1st, 2011 is going to be a big date, and there's going to be a lot of confusion, and there's going to be a lot of mistakes made. So it's very important that we look at this law, that we decide as lawyers how we're going to handle these various issues, that we update our forms, and that we educate our clients and our other contacts that we deal with, other professionals, to make sure that this law is handled properly. Because we're going to have all sorts of confusion. If you sign a power of attorney after September 30, you need 2 witnesses and a notary. But if it's signed in another state after then and it's valid under the other state law, it may be okay. And you have to be qualified as an agent to serve under a power of attorney after September 30. So in some circumstances, you may have a valid power of attorney, but the agent won't be able to serve. So there's a lot of different things here that we're going to cover. But first, I wanted to let Judge St. Arnold introduce this topic and give us his general thoughts from the bench.
Alan, thank you. As a sitting probate judge, we don't frequently see the powers of attorney unless something has gone wrong. And anytime the legislature gets in and monkeys around with a new statute, there's always plenty of opportunity for new things to go wrong. In the land of litigation, the primary place that these powers of attorney show up is as a defensive measure in a guardianship case. As we go along here, I'm going to have a couple comments as we hit on different areas of the new law, things that I see primarily from the judge's point of view when the litigants come in with a problem and how simply the problem could have been avoided. As a former practitioner out there doing what you folks do every day, there's opportunities here for a practice builder. And Alan, as we go along, I'll throw those in as well.
Super. Please don't hesitate to interrupt me and to interrupt Chris throughout, even though I cannot allow to interrupt you. Okay. Page 11. Now we're going to talk about the new law, and I'm going to repeat myself a few times here. I just think it's good for memory when you go to a seminar or you listen to a webinar to hear the same thing 2 or 3 different times in different contexts. But if you have a power of attorney executed on or after October 1st, 2011, you have to comply with Florida Statute 709.2105. That's 2 witnesses and a notary. Now the notary can be one of the witnesses, and technically the witnesses can be related to the person who signs it, unlike the healthcare power of attorney and self-proving will statutes. So you're going to have some confusion there, but basically you need 2 witnesses, adults in Florida, and a notarization. If it was executed before October 1, 2011, it's valid. If its execution complied with Florida law at the time, that means 2 witnesses. Notarization was not necessary. Then power of attorney executed in another state is going to be valid if its execution in Florida if it complied with the state law at the time. We don't think, however, that a power of attorney signed in another state is going to allow springing. The springing power of attorney change is probably the most profound change that we're going to discuss here. And I don't think that a power of attorney signed outside of Florida after September 30, 2011 is going to be valid as a springing power in Florida. But I'm sure there's going to be litigation over that.
Let me jump in at that point. We do see occasionally powers of attorney and other documents come in from other states. And of course, the requirement that they be valid at the time and place executed is always an issue. I am not real current on the present and past law in the state of Wyoming. There's been arguments made to me that there is no law in Wyoming. From a practice builder standpoint, why would we even try to rely on that? If we know that the client has either an out-of-state power of attorney or it simply has one where the witnesses are no longer available, the time that I see these is when the competency of the individual is being questioned, when the power of attorney is most critical. And that's when the other side usually comes in and says, well, Grandma didn't know what she was doing when she signed that 4 years ago. We can't find the witnesses. Makes my job a lot tougher. So when you have these things updated, it might be a good time to be in contact with your client.
Absolutely. That's a very good point. And for some clients, we have powers of attorney for both states. If I have a client who spends a lot of time in North Carolina and a lot of time here, we'll often do a North Carolina power of attorney and a Florida power of attorney just to avoid confusion on both sides.
In practice, I would frequently be asked by the clients who, fearing that they would get another bill, would ask me, well, is the old power of attorney still good? And you have to give them the good lawyer answer of, well, maybe, yeah, probably. Well, then why do I need a new one? Well, I would always give them the doctor example. You need to have your hip replaced. You want the very best orthopedic surgeon you can find, but you don't want him doing it the way he learned in school 30 years ago. You want him using the most recent techniques. Why wouldn't they come in and get the most recent form of POA? And we're going to show how to improve upon the standard POA here during the webinar. So with the example of doctors stay current, why don't lawyers stay current? Get the client to stay current.
That's an excellent commentary. By the way, how does it feel not to have to send bills anymore?
I did like getting the checks.
Okay.
Would you speak with the governor, please?
Right. Okay. A military power of attorney is also valid in Florida. You're going to have confusion because we're going to talk on pages 19 and 37 about military power of attorneys, but the short story is if your client says they have one, tell them to let you do a Florida power of attorney as well. Then also a photocopy or electronically transmitted copy of an original will have the same effect as an original, and that's going to be important in a few pages as well. Page 12, 5 catastrophes that can happen as a result of this new law. The first one will be if somebody signs a springing power of attorney after September 30, 2011, it will be a nullity. It will be no good at all. They may buy this at the form store. They may get it off of easy forms on the internet, and it's going to be a terrible situation. Secondly, under the new statute, many of the powers that you would typically give an agent are not going to be valid unless the principal who signs the power of attorney actually initials or signs their name next to each power. That's the power to create an inter vivos trust, a power to amend or terminate a trust, which we're going to talk about later, powers to make a gift, which Chris is going to address on page 30, power to create or change rights of survivorship, power to create or change a beneficiary designation, power to waive rights under a joint and survival retirement arrangement, or powers to make disclaimers or to exercise powers of appointment. So you're going to have special provisions in your powers of attorney, and you're going to have your clients at least initial 7 times or sign 7 times if you want them to give totally carte blanche authority for everything that you would typically have been able to do just by one signature. Next, we're going to have people who sign these powers of attorney without 2 witnesses and a notary. Also, we're going to have agents who get compensated and shouldn't get compensated, because this is what I was talking about before. Under this new law, if an agent is not a CPA licensed in Florida, a lawyer licensed in Florida, or a trust company licensed in Florida, then they cannot act as agent under power of attorney and receive compensation. Well, that may not sound like a big thing, but if they are doing this for compensation and they sign a contract, is that an illegal contract? And what sort of laws are going to apply? So you're going to have to reach out to your clients who are professional guardians who are acting under powers of attorney and getting paid for it, and talk to them about what sort of arrangements are going to be made so that they can somehow help the client but have another fiduciary of record. So again, everything we've talked about so far, we're going to talk about again, but it's certainly something to put on your checklist. The other thing is there's going to be a lot of people looking at newspaper articles and saying, oh man, this is time for me to fool Uncle Joe into giving me a power of attorney so that I can borrow his money and hope to pay it back. You're going to have people coming into your office, believe it or not, with elderly folks seeking to take advantage of them. So you want to make sure that you establish who you're representing when they come in and whether this is a power of attorney that you're going to feel comfortable in drafting. If you get deposed the year or two later saying, why'd you allow Mr. Jones to do a power of attorney to his alcoholic niece, Matilda, who has now sold his home? So please be careful. There's going to be the ne'er-do-well people. We'll talk about them later, too. Page 13, a little bit of history. I always like to ask my law clerks about the history. The first power of attorney case we could find was only back to 561 BC. That's a long time for powers of attorney. That's almost as old as wine and prostitution. But then there's the Paramore case from France, which relates to the second page of our presentation. The first Florida case is a Florida Supreme Court case, 1847, where a letter of agency was not sufficient to represent someone in court with. All right, page 14, just some basics here. I think almost everyone watching this knows that a durable power of attorney has to have specific language that says that if the principal becomes incapacitated, it will continue. And we have a definition of incapacity here on page 14. And I think everyone knows that the principal is the person who sets the power of attorney up, and they can revoke it by expressing the revocation. In a subsequently executed power of attorney, we normally have the client revoke prior powers of attorney if they've changed their decisions. If they haven't changed their decisions, I don't like to revoke the prior power of attorney, because I think if the family stumbles on the old power of attorney, I don't see any reason why they shouldn't use it if it's the most convenient thing, or if they lose the new power of attorney. But the execution of a new power of attorney does not revoke a prior power of attorney. Page 15, this power of attorney will terminate when the principal dies. Now, the lawyers on the line all know this, but most non-lawyers don't realize it. You see, you have to pretty much tell people, you know, when Uncle Ned dies, you can't act under this power of attorney. Then also, power of attorney terminates upon incapacity if it's not durable. Upon the filing of a petition for involuntary guardianship, it's suspended. It's not terminated. We're going to fix our PowerPoint for this the next time around. But once they are adjudicated incapacitated, then the power of attorney is terminated. It's terminated on revocation. And under the new statute, it is also terminated upon dissolution or annulment. If you are married to somebody and you or they sue for divorce, once that's filed, the power of attorney has no further force or effect. So I think you would have to execute a new one if clients got into a divorce matter and then they made up and they think they have a power of attorney for each other. I don't think they do, because once that divorce petition was filed, the power of attorney was done.
Alan, let me ask the attorneys to please give a lot of consideration to the selection of the attorney in fact. I generally recommend that it be of a younger generation. There's no sense picking mom and dad if you're already retired yourself. I had one situation where a fellow picked his brother, and his brother was a cross-country trucker. That was very difficult to work with. So do give some practical consideration to who it is that's going to be there. Are they going to be able to function? Do you like their decision-making process and so forth, so that it really works?
I agree completely with that. Okay, page 16, again, the suspension of a power of attorney upon filing of a guardianship. And the statute continues to have emergency rules that would allow the agent under a power of attorney to act during the pendency of a guardianship with court approval. Page 17, I'm going to introduce springing powers of attorney, and then I'm going to introduce my partner, Crotty Denicolo, who's going to talk about these a little bit more. But the big point here is that if you have a springing power of attorney, which is a power of attorney that says, I appoint John Smith to serve as my agent if and when I am determined to be incapacitated, that power of attorney will continue to work as long as it's signed before before October 1st, 2011. So you need to get the clients who want these in to get them signed or to provide other safeguards. If the springing power is signed before October 1st, 2011, it will not be exercisable under the new statute until you have an affidavit of a doctor of medicine or an osteopath licensed in Florida who has the primary responsibility for the treatment and care of the principal. So it's going to be a pain to even use the old springing powers of attorney. So you might want to instead use escrowed powers of attorney, which Chris is going to get into. Also, it was just of interest to me for military powers of attorney. You have an exception at page 19 and 37. Again, try to get the clients to use Florida law. Now, we have the actual statute on page 18 on the need to use a licensed osteopath or primary care doctor who is the primary physician before a power of attorney can spring. I like that because the historic primary care doctor may be more cautious about allowing a power of attorney to spring if the client is being taken advantage of. Page 19, we have the military power of attorney rules, just so you have. I don't know about you, but when I see a statute refer to the U.S. Code, I like to have the U.S. Code in front of me. There it is on page 19. And now on page 20, I'm going to turn this over to Crotty Denicolo. Chris?
Thanks, Alan. I appreciate that. One thing to add to what Alan said, it's important to note that springing powers of attorney are no longer valid if executed after October 1, 2011, not just if they spring upon the incapacity of the principal, but if they spring for any reason whatsoever, then they're no longer valid, and that's something to consider because of a lot of powers of attorney that may spring upon the unavailability of the principal. Okay, as Alan said, we have the escrowed power of attorney as a possible way to get around the springing power of attorney prohibition now. What we can do is have clients execute several live powers of attorney and have them held either pursuant to an escrow agreement or have a provision placed into the power of attorney that only allows the agent to present a original copy, because otherwise a copy of the power of attorney would be sufficient. But if you put that provision in the power of attorney, and you can have the agent execute several originals, the principal execute several originals, then the agent can use those originals, go ahead and present them when the time comes as the principal wants the agent to act on his or her behalf. And as a result of this springing power of attorney prohibition, we're going to see a lot more revocable trust arrangements because under revocable trust, you can still have what's kind of like a springing trusteeship that would take effect upon the incapacity or some future event relating to the principal's well-being or availability. And it's very important to consider these things. One thing I do want to caution with that is that not all assets can be held under a revocable trust. For example, life insurance and annuity contracts should not be held under a revocable trust and should be held by an individual in order to be protected under the applicable Florida statute section, or Chapter 222. Likewise, IRAs and pension accounts, there may be some tax disadvantages to placing those into a revocable trust or out of the name of an individual, something to think about. There's also the idea of Section 1244 stock that might cause some tax disadvantages if it's placed into a revocable trust.
Chris,
Another key thing. Yes, Judge.
Yeah, Chris, I see this escrowed area as one that is going to be very fruitful for the litigants. You're the attorney, and the power has been escrowed with you. Imagine a situation. Alan, in his advanced years, begins suffering from middle-aged crazies, and he and Trixie are in the car on the way down to the courthouse where he intends to file his petition for dissolution of marriage from that kind and lovely wife he has. Well, en route, he has a car accident, and he is temporarily, and by that I mean several months, completely incapacitated in the hospital. His grieving wife, finding the petition among the littered remains of the automobile along with Trixie, decides to go to your office, demand the power of attorney, saying that he is incapacitated because I'm going to teach that son of a bitch a lesson while he's flat on his back in the hospital. Now, here you are, the attorney in the lobby. Do I turn that over or don't I? Well, let's go see the judge. Now, what am I going to do with that? If you're going to have these escrowed, I'm thinking you're going to need a pretty detailed escrow agreement as to when you turn it loose and when you don't.
I agree.
Yes, our escrow agreement says absolute discretion of the firm, the ability to interplead, and of course, the ability to be reimbursed for legal fees and costs incurred with our own counsel. I have one question, though. Do you have a picture of Trixie?
It seems that it's an area the attorneys are going to be most reticent to venture into. Your idea of the trust arrangement and all the many things you can do with trusts to cover specific concerns, I think are well taken. But the area of escrowing these, and then when we talk about photocopies, is another area that makes me shiver.
Yeah, I guess another idea would be just put it in the safe deposit box and let the client give the key to somebody that they trust, so that the law firm's not on the line. But if I'm going to do the right thing for my client, where do I want that power of attorney so that it's not going to be abused? Well, maybe the CPA firm would like to hold it.
or at a minimum, suggest an attorney that you don't like.
Right. I have several ex-partners I could think of that are extremely trustworthy.
Well, it's certainly interesting to see what will play out in the coming months and years under the new law here. But in using revocable trust mechanisms, it's also important to be cognizant of homestead issues that might arise. There's been a number of cases that have not followed. I'm sorry, a number of cases that have found that a revocable trust that owns a homestead does not entitle the grantor of that trust to the homestead protections under our Florida Constitution. It's important to think of those, although it's probably not good law as indicated here on this slide 22. It's certainly worthwhile to look at that. Another issue to consider is tenants by the entirety's property cannot be held under a revocable trust, and for creditor protection purposes, it's not optimal. Certainly want to look at that. Okay, and on slide number 23, we have kind of a continuum of capacity here, and we were looking at this and we were thinking, well, what are the levels of capacity needed to prepare a power of attorney, execute a power of attorney, or a will or a revocable trust? And generally, what we found is that a power of attorney under the restatement of agency provides that the level of capacity required is kind of like an equal dignity situation, so that the principal would have to have the same capacity to create power of attorney as the principal would have to have if he was performing the acts under the power of attorney. And it seems to be pretty logical. A lot of powers of attorney would give the power to the agent to amend or revoke a revocable trust. So therefore, the same capacity that the principal would have to have in that regard has to be under the power of attorney. And as we're all familiar here, and remember back to the days in law school, we learned about the capacity for a will, and I'm sure that the judge sees a lot of that in his courtroom every day. But with these issues, we have to be cognizant that it's our clients come in, and we don't want them to be taken advantage of. And in the same vein of having an untrustworthy agent serve, we also want to make sure that they're aware and have this level of capacity as to what they're doing with the power of attorney and with other documents as well.
And Chris, let me interject here. Our living trust form does not allow an agent to make changes, because so many times clients will appoint their children as agents under powers of attorney because they expect that that's going to allow the children to sell the house and sell the car. But if they have several $1 million of assets under a living trust, we typically specifically provide in the living trust that the agent under a power of attorney will not have the authority to change the trust. And now that this new statute is going to have a provision to initial as to whether you want your agent to be able to amend the trust, I think lawyers are going to have to be careful not to be inconsistent. I don't think we're going to have our clients initial that they want the agent to be able to change an existing living trust, because then we're going to be inconsistent if our trust agreement says that agents can't change it. They're going to ask the law firm, why do you have it both ways? What was intended? So I think you're going to have to make that clear one way or the other, and I think for most of us, we're not going to want the agent under a power of attorney to be able to amend a trust agreement. That's just something to think about. Okay, I'm going to I'm going to pick it up here on page 24, and I'm going to try to pick up the pace a little bit as well. The new law, as you can imagine, with the banking industry being what it is, has probably 2/3 of its text by and for the banking industry. And the banking industry was, of course, concerned about how much time they would have to accept or reject a power of attorney. It's going to be 4 business days that they have to accept or reject a power of attorney. And then upon rejection, they must state in writing the reason for the rejection. And they aren't required to accept the power of attorney if they don't have any obligation to engage in business with the principal. Also, if they do improperly refuse to accept it, they're subject to a court order, and they're subject to liability for damages, including attorney's fees incurred in the action or proceeding. So I guess you want to sue them earlier rather than later to get those attorney's fees and costs incurring if you do have, imagine this, an unreasonable financial institution. All right, page 25, someone who in good faith accepts a power of attorney can rely upon the power of attorney. There's something very specific in the statute that if one bank officer knows that the that the power of attorney is bogus or not effective, but the other bank officer who accepts it doesn't know, then the bank is not responsible. Knowledge of one bank employee is not imputed to the other bank employee. Page 26, there's an affidavit that the bank can require. So if they want to slow you down, they'll ask you for this affidavit. So here it is on page 26. Page 27, here's the qualifications and requirements of an agent. They can be in jail. There's nothing that says they can't be in jail and be a committed felon, but they have to be a natural person who is 18 years or older, or a financial institution with trust powers. And then to receive reimbursement, they have to be qualified. To be qualified, they have to be a spouse or an heir, or a financial institution, or a lawyer or CPA licensed in Florida. I thought it was very interesting and also very appropriate that the legislature chose to recognize CPAs as having a good feel and a good background for handling fiduciary duties. And then if they're going to be paid, they have to be a person who is, if you're not a spouse, heir, financial institution, lawyer, or CPA, you have to be somebody who has never been an agent for more than 3 principals at the same time. Now, I don't know what the heck that means, whether you've been an agent for 3 principals at the same time. I guess they're looking for people who have been in the business of being agents. But if you have a big family and you've been helping your mother and your father and your uncle, then you wouldn't be able to be employed by your next door neighbor for the time you would spend as their agent. Now, page 28, co-agents, if your power is not specific, if you have co-agents, each agent can act without joinder of the other. So our documents always say we'll act with joinder and consent of the other required, or without the need for joinder or consent. So we don't really want to be reliant upon a statutory interpretation, but that's the way they worked on. That's the way it came out. Then you can designate one or more successor agents, and you know what? You can put in your power of attorney that your successor agents will have more or less of the duties than your primary agent. The client may want to appoint their spouse to have any right whatsoever, but may only want their children to have limited rights. So if you want to get into the details, you can. Page 29, just a little bit about avoiding financial scams. I've got some quotes here about some people who just lost their savings to some scam masters. And then I have a provision here on page 29 that you may want to consider to make the agent only invest in FDIC-insured bank accounts, CDs, and also if they go to brokerage accounts, that they would have to be with SIPC-insured brokers that would be handled in a fiduciary standard, because we really don't want a naive agent to go put these assets into an aggressive brokerage account and lose a lot of monies. Brokerage firms have fiduciary accounts where the brokerage firm takes a lot of the burden. So if you're representing an agent, you want to make sure that they're using those. Then I have also that has to be at least AA Standard & Poor's rated. That way they can buy U.S. Treasury bonds, sadly enough. Okay, yeah, it was AAA when I first would have drafted this. All right. Then also powers requiring separate signed enumeration. I mentioned before, powers to create a trust. I do want to give the agent the power to create a trust because we've used that many times, but I personally am not going to give agents the power to amend, revoke, or terminate a trust unless I've really talked to the client about that. Then we talk about gifting here, and I'm going to let Chris talk about gifting a little bit more towards the end. But this is interesting. You have to give the power to gift in order for certain agents to be able to make gifts. But even when you say, I give the power to gift, and the client signs to the left of that or the right to that or initials, the gifts are limited to only $13,000 a year per person unless there's even more language. So you're going to have to burrow into this law a little bit in order to make sure that your powers of attorney for gifting are set up properly. Then again, the right to create or change rights of survivorship, the right to create or change beneficiary designations, waiver of pension plan rights, disclaimers, powers of appointment. You're going to have separate provisions, and your clients are going to be just initialing until their arthritis is totally felt.
Alan, let me chip in on the gifting part of it. It would be very helpful to me if there's specificity there that's consistent with the lifestyle of the individual client. If you have near-to-well adult children that are being supported, I frequently see that. I see stepchildren, adults that are being supported. Lifestyle issues. Grandma always went on ski trips to Vail. Grandma always went on cruises. I think those are reasons for her to gift to me and my family to go with them. Whatever the specifics of the client's lifestyle are, if it includes a gifting pattern, it's helpful to me that it's in there because I am asked to approve some of the darndest things.
Right, I agree. That's a very good idea. We're going to incorporate that into our language. What I'm going to do, because we promised that this will be a 45-minute presentation, but we're going to extend it to 50 minutes so that we can apply for continuing education credit. Then I'm going to let Chris talk about gifting. Probably after we've signed off, Chris will do a little 5-minute clinic on gifting for the small percentage of you who want to hear that. Page 32, this is interesting. There are some modifiable duties where unless you say to the contrary, your agent has to act competently. That's really interesting to me that you could authorize your agent to act incompetently. And then loyally, your agent has to act loyally, but you could modify this to authorize your agent not to be loyal. Impartiality, you can authorize the agent not to be impartial. And cooperative with healthcare providers, you could authorize the agent to not cooperate with healthcare providers. This is pretty interesting because if I'm going to appoint my wife for a really difficult duty, and assuming that I don't do the Trixie thing, I might want to actually go ahead and modify this so that she doesn't have to be competent, she doesn't have to be loyal, she doesn't have to be impartial. She can do what she needs to do for our family. It's going to be very interesting to see what people do with these types of provisions when they're totally trustworthy of relatives or close friends and want to lower the standards so that the person who acts for them doesn't have to worry quite so much about getting sued. Then there are mandatory duties that you cannot waive, such as the duty to act in good faith. This is interesting. The duty to preserve the principal's estate plan, a statutory duty when you act as an agent, to know the value and nature of their property, to know their foreseeable obligations and need for maintenance, to minimize taxes, including income, estate, inheritance, generation skipping, and gift taxes. This puts a lot of burden on an agent under a power of attorney. And then eligibility for state programs. If you act in good faith, you're not liable to a beneficiary. But how do you act in good faith if you don't get advice from their tax lawyer or their CPA? So this was a very interesting provision that must have had a lot of deliberation at the bar level. And then they must act personally. They cannot delegate the authority to third parties. They must also keep adequate records. That's new. So they really have to keep a log, and we have a sample log on page 35. And they have to maintain an accurate and current inventory of the safe deposit box if they go into the safe deposit box. And if somebody with authority asks them for a report, they have to comply within 60 days. So it's certainly a tightening up of the responsibilities of an agent under a power of attorney. So are you as a lawyer going to have an instruction letter? Dear agent, you have been appointed as an agent under a power of attorney. Here are the Florida statutes on your duties. Please let me know if you have any questions. Here is a sample log. Here is what you need to do. And then what is the responsibility of the lawyer who is representing the agent? Is your client the agent or the principal? And can the agent waive a conflict of interest if you were representing the principal and now you're helping the agent? Or do you need to refer that agent to another lawyer? This statute brings up as many questions as it answers, but it's going to be very interesting over the years to see what happens and what fleshes out.
Alan, please go over that record-keeping provision with your clients very, very carefully, because when the litigation hits, the very first notice to produce is going to be all of those records.
Right, right. And then they'll have 60 days to find them. Okay. Page 36, there's a lot of new statutory language on accepting the powers and responsibilities by the agent. And there's a lot of statutory language now on the authority of the agents. They basically gave the agent specific authority to do things like convey or mortgage the homestead or make health care decisions and other things. That you'll want to just be familiar with these things. We have included the Florida statutes for financial institutions, which are referred to often in these provisions. And then liability of agents. Yes, believe it or not, there will be liability to restore the value of what you've done wrong, to reimburse for attorney's fees and costs paid from the principal's funds on the agent's behalf. That's interesting. So if I'm the agent for somebody and I do something negligently and I get sued, I don't owe attorney's fees and costs except for those that the principal paid for my own attorney's fees to defend the action. That was an interesting compromise, I'm sure. Then I'm not responsible for liabilities caused by acts or omissions of another agent. I'm not responsible for making sure that the prior agent did the actual job right unless I have actual knowledge of a breach or imminent breach. So just like the trust area, when you take over a trust, there's going to be some duty to make sure that you at least don't have actual knowledge of a breach or imminent breach, or possibly to go to court and get an order after notice to all interested parties that you don't have any responsibility and that no one involved knows of a breach. Then I go to a letter, and this is the big challenge for us in practice. Are we going to get a letter out to our clients, and what is this letter going to say about the new Power of Attorney Act? One thing it's going to say is, you got this letter from me before you read about this in the St. Pete Times and got all concerned. You heard it from our law firm first. There's a new law out there. We really haven't had time to open the file for every client to see how this new law affects you, but you are invited to call us, and we will pull the file and tell you how this new law affects you. It probably will not affect the power of attorney you now have in place, but it might. So that's the editorial slant that we've taken on our letter, and we're gathering addresses, and we're going to be mailing this out just to try to avoid the confusion. And then something that works well for us on page 45 is some clients will check a box and fax this back to us. Some of them will PDF it back, some will fax it back, some will drop it by. That's going to be easier than getting a lot of phone calls. And then if they're interested, we'll be glad to send them a copy of their power of attorney, and we could talk about their will and trust at the same time. And by the way, there's a new $5 million estate tax exemption, et cetera, et cetera. On to Excedrin. So, page 46, back to Judge St. Arnold. What do you think?
Couple thoughts here. There's a number of attorney fee references in this new statute. I looked at it from 2 points of view. For those of you that are litigators out there, this opens up a whole new area for possible litigation if fees are awardable. For those of you that are simply drafting these, please know that somewhere at some time a litigator is going to be reviewing your work. So when you draft it and you make these decisions with your client, please make real sure that this is in the back of your mind. The other thing that jumped out at me is there's a number of references in there that say except as otherwise provided, and then it goes on. To me, that's an invitation from the legislature to improve upon what Tallahassee has done for my particular client. Every client is unique, so every POA that you do should be unique. There are many opportunities in here to alter either liability or activity, or in some way make this do what your client needs to have done. And I invite everyone to use this drafting opportunity to do exactly that. If indeed you're going to exercise that right, use the statute number. Pursuant to 709, whatever it happens to be, we're providing otherwise, and then put in what it is that you do provide. That makes your service better than just simply running something off of your word processor.
That's excellent. So, Judge St. Arnold, thank you so much for your comments today. They were very insightful, very practical, just as when you practice they were very practical. And thanks for what a tight ship you run at the probate court. You do a fantastic job.
Well, I appreciate that, and it is cocktail hour, so it's time to get a little tighter.
That's right, exactly. Okay, so for the 93 remaining attendees, if you want to stick around, Crotty Denicolo is going to talk now more about the gifting implications of these powers of attorney. Also, we are going to set up a blog. It's going to be at www.gassmanlaw.com, Power of Attorney blog, HTML. Janine is going to send everybody the website address. Please feel free to give us anything you would want to post on this blog. We'll be posting a lot of information, and we'll just try to share what we have because we're all together in this, and we'll all working together make this better for ourselves and clients. Chris?
Thanks, Alan. And one thing I want to point out with gifting that I think we mentioned briefly earlier, when there's a gifting power in the power of attorney, if it doesn't provide otherwise, then that gifting power is only available for someone who's an ancestor, a spouse, a descendant of the principal. Otherwise, third parties that aren't related to the principal cannot make gifts to themselves by use of the power of attorney. And that's important, I guess, to cut down some of the potential for fraud and misuse of that. And as Alan discussed earlier, if there is no other language in the power of attorney, it's only limited to that $13,000 per year, which by no coincidence is also the amount of the gift tax annual exclusion currently. The new power of attorney statute also provides that the agent may consent to a split gift, which would allow up to $26,000 to be gifted if the principal is married at the time of the gift. And with this, lost in all of this is the federal tax implications of the agent's authority to make gifts. And one question that Alan and I were discussing earlier today is whether an agent who has the power to make a gift to himself under a power of attorney has what's called a general power of appointment. And the implications of that would be the assets subject to this general power of appointment would be subject to estate tax in the agent's estate if the agent passed away. And I did a little research on it this morning and unfortunately could not find any clear answer.
That's a surprise.
Yeah.
The tax law has no pure answer. I can't
Not even
believe
one case on it, not even a discussion of it. And there's conflicting arguments here that you can think of. On one hand, you have a general power of appointment for federal tax purposes if there are any powers in which the person who holds the power can transfer property to himself, his creditors, his estate, or the estate of his creditor, or the creditors of his estate. So it doesn't matter what it's called. I mean, you can call it anything under the sun. If it has those powers and if the agent has that power, then usually it's found to be a general power of appointment. But conversely, if you have a general power of appointment, or if you have a power to make a transfer of assets to yourself as an agent under a power of attorney, and if that power of attorney is revocable by the principal, then that could be seen as requiring the joinder or consent of the principal before making the gift. If you have that situation, if a power requires the joinder and consent of the principal, then you don't have a general power of appointment, and in that case, you wouldn't have these adverse tax consequences here. But as I said earlier, there's really nothing in the law that gives us an indication as to what the conclusion would be in front of the IRS. But in any event, in light of this uncertainty, it's advisable to draft the power of attorney to limit the agent's power to make gifts to himself if estate and gift taxes are a consideration and a concern here.
Or maybe, what if you required the consent of an adverse party or a financial institution or a fiduciary before the agent can make gifts to themselves?
Well, the thing is, if you have just any power to appoint it to yourself, it could be seen as a general power of appointment. We just don't know. If it's an irrevocable power of attorney, then in that case, you probably have more of an argument that it is, in fact, a general power of appointment, and you would have estate tax if the agent passed away holding that power. So it's unclear. It's unusual to see that, but it's something to consider. Another consideration is actually giving the gifting power to the agent. You don't have a taxable gift upon the principal signing the power of attorney that allows the agent to make gifts, and that's pretty well settled in the tax law. But once the agent makes the gift, whether it be to a descendant, to a spouse, to whomever, you're going to have a taxable gift. And if to a spouse, of course, you'll have the marital deduction apply, and you'll have unified credit and things like that apply. But still, it's something to consider, and these issues really are often forgotten when powers of attorney are discussed. Especially with our clients that are high net worth clients, and we really don't want to have adverse tax consequences come up. When we're not even expecting them, to say the least. So, Alan, I'm going to pass it back to you for conclusion.
Okay, well, I want to thank the 83 people who are still on the line here. Most of them are not surfing the web, but have been listening. I hope that we'll get a lot of good questions, comments, and suggestions from you. My plan is to go ahead and finalize our new durable power of attorney form, and then to offer another webinar on a clinic on the drafting of the power of attorney and the language we've come up with. If anyone would like to participate with us by co-presenting that, please let me know. There's a lot of smart people on this webinar, a lot. I'm really respectful of everybody who's on this, and would appreciate your input. We're going to go ahead and sign off now. This is going to be available on our website. You'll only have to go to our website and click a button sometime tomorrow, and you can watch this webinar, or we are going to replay it a week from today at 6 p.m. But if you'd like a private replay and you're not sure exactly how to see it on our website, just give us a call, 442-1200, and we'll be glad to walk you through it. It's 5:53 p.m. What are you still doing at the office? Have a great afternoon. Thank you.
Thank you for including me, Alan.
My pleasure. Thank you so much for staying on to the end. And I hope everybody's desk is cleaner now.
All right, we'll see you in court.
All right.
Thank you, Judge.
I hope not.